Yeah.
And I'm going to. Right, good morning everyone. I'm just going to quickly kick us off with karakia for the start of our hearing four. Hau ki rongo kia rangi e tū nei, hau ki raro kia papa e takoto nei, haki roto ki te ngākau tangata, hau ki waho ki tēnei hui. Haumie, huie, tāke.
Tēnā koutou katoa, nā mai, haere mai ki tēnā hui, ko Robert Scott Taukaongo. Good morning everyone and welcome to day one of hearing four for the proposed Far North District Plan hearing. My name is Robert Scott, I am the chairperson for these hearing proceedings and they'll be held here and throughout the district for the next 15 or so months. With me on this panel, to my right is Commissioner Alan Watson. Good morning. And to my left, Councillor Felicity Boyd. Commissioner Siana Walker. And Commissioner Peter Kensington. So this is a hearing under the Resource Management Act to consider submissions and further submissions on the proposed Far North District Plan. We've been appointed by the Far North District Council as independent hearing commissioners to hear submissions and make recommendations to the Council on any changes to the district plan as notified. We are not intending to issue interim recommendation reports at this stage. We'll be hearing all the submissions before issuing a single tranche of recommendation reports. That said, we do intend to hold interim deliberations at the conclusion of each hearing topic. I think we're reasonably familiar with the participants here and online at the moment, so I don't think we'll do a summary of our backgrounds. But we would ask that the council officers just quickly introduce themselves and their roles in the proceedings for this hearing.
Morning koutou, my name is Jerome Wyeth. I'm the Technical Director of Planning at SLR Consulting based in Ōmāpere, and I'm the Reporting Officer for the Coastal Environment and Biodiversity topics.
Kia ora koutou, my name is Ben Lee. I'm also with SLR Consulting based in Whangarei. I am the author of the Natural Landscapes and Features report and the Natural Character.
Kia ora koutou, my name is Malene Absalom. I'm a landscape architect, resident in Waimate North, so not far away. I have been reporting to the Council on the coastal environment, natural character and outstanding natural landscapes, but not outstanding natural features.
Morena te whanau, ko James Gordon Takunga, District Planning Team Leader, Far North District Council.
Tammy Worcester, Manager of Integrated Planning. That's the manager responsible for the district plan and also our growth planning and placemaking.
Thank you very much and welcome. I just wanted to ask the 42A report officers, are there any procedural matters or late submissions that we need to address?
No late submissions. We do have one missed further submissions from Lucknow Farm Limited, and I will address that. And for the coastal environment topic, and I will address that in my reply.
Okay, thank you. Okay, and I think everyone who's in a hearing has, everyone who is present today is familiar with the hearing process, so I will take all of those as read. But we will just quickly undertake some housekeeping matters, and I'll go to Alicia Kate to describe what they are.
Perfect. So everyone, you will have seen the bathrooms are just out this door here, or if you head back down to reception, there's some bathrooms there. In the event of a fire, head to your nearest exit, which will be this one, or again back out to reception, and the gathering place is the grass area out the front there. If we can all just make sure we've switched our phones off, or at least to silent. We are recording today's proceedings and this will be put online later, so just so that you're all aware of that. If anyone wanted to record the proceedings themselves, they would just need to check in with Robert, our chairman. And we are aiming for breaks at 10:30, 1 and 3:30 today, obviously with a little bit of flexibility. Thank
Thank you very much. Now, we are going to have a number of presenters today presenting their evidence via video, and we've got a big screen here. We've tilted the chairs so that we can possibly give you a view. I think what's going to have to happen is we're going to have the screen tilted our way a little bit, but we put your chairs on a slight angle, not to stop you looking at the magnificent view, but just so that you can potentially see those proceedings. If you want to shuffle around to get a view of other people presenting evidence, you're more than welcome to do so. Other than that, we'll go to our first submitter, which I understand is...
Sorry, Jerome, section 42.
Oh, right. Oh, sorry. And you're going to be doing an introduction to your council. Got a presentation as well?
Yeah, we were planning to do a presentation for the full topics covered this morning.
Yeah, that's right. Sorry, I've got a bit of a false alarm. I'm stuck there. Stand easy. And we'll go back there to your presentation. And you wanted to address the further submission? Or is that going to be...
That'll be in the reply.
At the reply,
yeah.
okay.
So,
Again, so can you see this, everybody else? You're okay? Right.
Is that working? I wonder if you just... That is all. Sorry, guys. No. Are you okay just to look at me and I
yes.
tap it through?
Yeah.
Is that okay?
Yeah, that's fine. So what we were planning to do for this introduction session, I believe we have an hour and a half, is for recording officers and our experts to do a presentation for the four topics. So firstly, we were thinking that we would focus on the natural character, natural features and landscapes and coastal environment topics, because they share a lot of similarities in terms of the issues raised in some of our recommendations, and that will be followed then by the biodiversity topic. So can you move the slides, please, AK? Presentation.
Oh, dang it, it's not working. Okay, this is... Right, where is that? It is actually now
Next
working.
slide, please. Here we go. So what we're planning to cover, just a brief introduction to the topics. Mr. Lee is going to cover some of the key provisions of national direction and the RPS, including the direction to avoid significant adverse effects. We'll then provide a sneak overview of some of the key issues in submissions and our recommendations, focusing first on those common issues across the three topics. A brief summary of some of the issues based on evidence that has been pre-circulated, and then questions, and we're also obviously happy to take questions throughout that's preferred by the panel. And then, as I said, I'll cover the biodiversity topic following that, and we also have Mr. Fisher online, who's legal counsel for council, and then we'll talk to some of the more specific legal issues around giving effect to the National Policy Statement for Indigenous Biodiversity. Here we go. So this is really to show a snapshot of where these topics sit within the PDP. So three of the topics sit under the Natural Environmental Values chapter, under district-wide matters, in accordance with the planning standards. The coastal environment sits under general district-wide matters, and represents quite a key shift from the operative district plan, which primarily managed the coastal environment through zones rather than overlay. And also just to illustrate that these topics are not confined to the chapters themselves. We also address provisions in other chapters, including the subdivision rules as they relate to these overlays, a number of definitions that are specific to these topics, and also Appendix 1, which is the mapping methods and criteria for identifying these overlays. You'll all be aware of this, but just really to sort of emphasise and recap that these chapters are key in terms of meeting obligations under Section 6 of the RMA. And more specifically, the natural character and coastal environment chapters directly relate to Section 6A in terms of preserving and protecting the natural character of the coastal environment and water bodies. Natural features and landscape topic directly relates to section 6B in terms of protecting these areas from inappropriate development. And lastly, the biodiversity chapter is directly related to section C in terms of protecting areas of significant biodiversity.
My turn.
Your turn.
So as Jerome alluded to at the start, there's some real commonness across these three chapters. So we thought that it's just easier to kind of package them up and talk through a number of the common issues across these three chapters. But there's also some issues that are a little bit more specific, chapter by chapter, so we'll address those sort of at the end of this section. So first up, starting at the top of the hierarchy, just headlining the national policy statements. Obviously, the NZCPS is our leading document in the coastal environment, and the two key aspects coming out of that is starting the setting up this bar of avoiding adverse effects on those outstanding things, and then you must avoid significant adverse effects on other natural character landscapes, etc. The NPS for freshwater is probably only really relevant to the natural character chapter, which is focused on the margins of freshwater bodies. So it does signal that that requirement for district councils, district plans to manage adverse effects of development on freshwater health. So it's not just the regional council functions; there are some district council functions there as well. Also, importantly, it talks about this value around natural form and character as a freshwater value, and you would have seen in my report a recommendation to adopt its description of natural form and character as some criteria for natural character to apply to freshwater margins. So I just wanted to highlight that there. There's a couple of key NESs and that overlap with the matters that are covered in the chapters. So earthworks and vegetation clearance is a particular one. So under the NES for fresh water, that overlap really occurs within 10 metres of wetlands, and as you know, there's some pretty strong requirements under the NES when it comes to earthworks and vegetation clearance in that 10 metre area. The plan can be more stringent in relation to that NES regulation, but it cannot be more lenient. Now, when it comes to the NES commercial forestry, obviously there's been an update on this relatively recently. So it's been broadened and now includes carbon forests. So now we have also that overlap with afforestation. Under this NES, it's slightly more complex, but plan rules can be more stringent when it's looking to protect those sort of higher value type things, natural character and coastal environments, significant indigenous veg, etc. now in ONF. And then for afforestation, there's a lot more flexibility, so a plan can actually be more stringent or more lenient. And those are all important given that the plan does have rules in that respect. Come down to the RPS, and this is probably the most pertinent policy, and it starts to really set that framework around the levels of acceptable adverse effects, those bars, so to speak. So if we go across, I'll look at it across the table, it's probably easiest to explain. So for those outstanding things, within the coastal environment, that bar is avoid adverse effects. Outside the coastal environment, it's avoid significant adverse effects. Coming down and looking at those that are not outstanding, so those others, within the coastal environment, the bar is avoid significant adverse effects, and it's then actually silent outside the coastal environment where it's not outstanding. Now, the natural character of fresh water, slightly a little bit more complicated, but the way that the RPS does it is that where it's in the coastal environment, it's captured under the broader definition of natural character, and therefore within the coastal environment, the test is that the bar is avoid significant adverse effects, but then also outside the coastal environment, that bar is also avoid significant adverse effects. So it's a little. Now, also just wanted to highlight this particular method. And this method is important because it's about recognising existing development and its status, I guess, within these areas when they're mapped. And I was involved in the development of the RPS, and it was just after the days of King Salmon coming out, and so there was a lot of debate around how does the plan, how do you deal with development, etc., within these outstanding things. So one of the things that is really emphasised is that, hey, if you've got existing development and you've mapped it with that existing development in it, then you should recognise it, and then as best as we can, continue to be able to provide that development. Now, this is not saying that you provide for it at all costs. You still need to meet those policy requirements, but it's giving that signal that existing development in those areas is okay, more or less, in a general sense. This whole avoid adverse effects thing, avoid significant adverse effects thing it's an important element for these 3 chapters, and it really helps. It's really, obviously it sets the direction for how the policies and the rules then take shape. One of the challenges is how do we deal with the rules when it comes to particularly the things that we need to avoid adverse effects on. Now, if we think, first of all, we're thinking about our permitted activities. Now, when we look at that permitted activity, we need to be ensuring that the activities that it permits is avoiding adverse effects. That's the bar that we need to meet. So it's a little bit of a challenging bar to meet because you could apply a really strict interpretation and go, well, actually, anything could have an adverse effect in permitted activities. That's not reasonable, and our job is to try and take a more nuanced and assessed approach to actually going through and trying to make a call on what types of activities do we think we should and can meet that bar. The way we've looked at that is particularly those that have come and put forward, hey, can you please add these activities to the permitted activities list, so to speak, is a judgment approach based on the likelihood of adverse effects arising. So we've had to look at that activity and go, look, in the main, that activity was to occur, what likelihood will there be effects arising that would mean that bar, you could meet that bar. We've then sort of added a little bit of additional weighting where you've got some policy that might be supporting an activity, e.g. infrastructure, and or if it's something that's really critical for health and safety, that's given it a little bit of weight, so to speak, in terms of being able to make the grade of going on that permitted activity list. Now the challenge is, because the permitted activity rules within these chapters cover both areas where it's avoid adverse effects and areas where it's avoid significant adverse effects, it's then what happens when you're not permitted. And I'm going to go to the next slide actually. For those visual people out here, so this is trying to sort of capture the situation. So imagine this is like a range of activities, broad range of activities. Now, we've got a permitted activity rule that captures a chunk of them and says, right, you are permitted. Now that permitted activity rule, as I said, covers both avoid adverse effects and avoid significant adverse effect activities. Once you get outside of that, the bandwidth or the range of activities that you have until you're going to meet that avoid adverse effects bar is pretty small, okay? And that starts then to set the tone then for why you have a non-complying activity for those activities, generally, outside of that permitted activity range. Now the avoid significant adverse effects bar, which gives you more scope, gives you more spectrum, there's more activities in there that will still be able to meet that policy requirement of avoiding significant adverse effects. So that gives you more scope to be controlled, maybe RDA discretionary with your rules. So yeah, that's kind of conceptually how we've looked at this. So I'm going to jump now into go through some of the key provisions here and the key issues that are raised in submissions and those sort of recommendations. Apologies, the text is a bit small there. So so starting at the top, one of the things the submissions we got was around aligning those objectives with the higher documents, and we had some sympathy with those submissions. We felt that the objectives weren't quite aligned wording-wise with those higher documents. So we've tweaked that wording, we think, to better match that alignment, in particular with the RPS and Section 6. In terms of using that language about preserving and protecting and inappropriate land use and development, etc. Another thing raised in submissions was the terminology in terms of how you refer to ONL and ONF and what it is that you are avoiding effects on. The previous wording was in a general sense around avoid effects on ONL, avoid effects on ONF. The RPS, for example, uses language and it's really focused on characteristics and qualities and really pulling out what are the aspects of those things that are the things that need protecting, that make it outstanding. Those are the things that are really important. And so hence we've used that language and support using that language. There is a question about what words to use, characteristics, qualities, and values. What's the phraseology there? As you have seen in the report, you go and have a look at the higher documents and the worksheets, and it's a bit of a mix of words that are used there, and there's no consistency. And so we thought, from a kind of a cover the field point of view, let's use all three of them to remove any sort of ambiguity, and so that everyone knows that, well, however you interpret that, all three apply. The policies around enabling use and development of provided purpose zone land and treaty settlement land, we thought the original wording conflicted a bit with the avoid policies, just the way it was worded. So we've suggested some tweaks to there, and we've also tweaked it so it's around more recognising the adverse effects arising from those activities may actually be acceptable to support the well-being of tangata whenua. So it's giving a bit of a leg up, I guess, to where you've got a development that's having such effects. There's also a policy around sort of prohibiting land use and development that would destroy characteristics and qualities. We didn't like that policy. We didn't think it was good. We didn't think it actually reflected the wording, the intent of the wording of higher level direction. And you've already got an avoid adverse effects type policy. You can use that as the basis then for prohibited activities if you think it's necessary. So hence we suggested deleting it. There's always the age-old issue around how do you deal with NES conflicts and removing those conflicts, and it's having been involved in quite a few plans in this issue, it's never easy. You can't just cookie cutter out, oh yeah, actually, it doesn't, it's too hard because rules are nuanced and they don't completely overlap nicely, easily with each other. So we've taken the approach of notes, and so basically a note at the start of the rules section that explains the relationship between the rules and the NES where there is that overlap. And you'll see that there for both the freshwater and the commercial forestry NESs. It had some submissions around activity status. We've already got an approved building platform, so we've been through consent, landscape issues were assessed, consent granted, there's no doubt the conditions on the use of the building platform, some kind of, some base kind of conditions around use of it from a landscape perspective. We were sympathetic to the call from submitters about not needing to relitigate those issues again. If you've already addressed those through a subdivision process, it's unfair to then have to go back and relitigate those again. However, there is a need to fine-tune, accept that, and we thought that a controlled activity was the right tool for doing that. So that's what we recommended. Activity status for permitted activity non-compliance. So no surprises here based on our sort of thinking around how you look at adverse effects and avoiding adverse effects, etc. Non-complying, we're in the coastal environment for those activities that can't meet that permitted activity rule. HNC, we've said discretionary, albeit the bar is avoid significant adverse effects. The way that they are mapped to the very discrete, sort of tight, small kind of areas, and therefore they tend to be more sensitive to development, and hence why they've got a bit of a higher bar around being discretionary. All other areas where the bar is avoid significant effects, we felt that restricted discretionary was appropriate. At the end of the day, these chapters are around managing those particular effects and those particular issues that are identified in that chapter, and therefore we thought that restricted discretionary activity status was appropriate for zooming in and making sure that that's what you're zoomed in and looking at when you're looking at a resource consent that might be having an impact on these values. Getting down into the rules now. So there's a consistent rule across these three chapters around repair or maintenance, and we're just reading the rule and trying to interpret it. We didn't think the rule was actually doing what was intended. Long story short, it basically meant, so it had a list of activities that said repair and maintenance with like for like is permitted, otherwise you jump up to, sorry, I can't remember the activity status. What it meant was that if you weren't an activity on that list, you weren't actually captured by the rule, so you didn't actually go to being a consented activity, you just weren't captured by the rule, full stop. And so it was not doing what it was actually intended to do. The other thing is that if you look at the list and the things that are like tracks and roads and those types of activities, if we're thinking about if there was an intent to wanting to ensure like for like with the repair and maintenance with those activities, it just didn't seem, we didn't quite see the logic in it, because you know, what would a like for like maintenance and repair of a track look like? Is it, you know, is it the same gravel colour? I don't know. So there were some challenges we sort of thought with the rule, and we thought ultimately we're thinking about potential effects on those things we're looking to manage here. We didn't think it was an issue, and we didn't need to have that rule.
So let's ask a question on that.
Sure, I was almost going to do the same.
Sorry to interrupt. So you couldn't resurface a gravel track with a concrete surface as a like for like.
Correct. That wouldn't be like for like,
yeah.
And therefore you would. So under that rule, you would then fall to be, you need a consent to do that activity.
Right. But now we're saying get rid of that rule altogether.
Yeah.
And so
that would then be allowable. Yeah, it wouldn't be captured by the rule.
But
it'd be subject to the controls on building size and earthworks and vegetation appearance.
Right.
But it was unclear sort of what like for like actually means and how that would be tested in an activity condition.
But you could, as a permitted activity, concrete that track.
Correct. Yeah.
That might be.
Yeah. That's a good question. I don't know if you've got a thoughts on that, Malene?
Well, this is going to be the question I was going to ask. Is like, how do you define like for like? You can make it literal, and there is a like for like wording in another instrument that I'm sure people here are familiar with, where you interpret like for like literally as like being an exact replica of, or you take it more figuratively, which is like, you know, sort of similar. And this concrete track thing could be an example of that. If you're concerned about impermeability, then it's not like for like. But if you're concerned about visual and width and scale, then it would be. So is that the issue you took with that? How do you define like for like?
Absolutely.
All of the items are holdable.
Yeah.
Absolutely of the instrument.
Exactly.
Okay, so thanks. We were trying to give you a clean run, but
please feel free to jump in. I'm really happy to.
I'll give the rest of the panel the opportunity to jump in with some clarification questions as we proceed. But I am conscious also that we've got a really tight time frame today. So thank you very much for that.
No worries. Right, so across the rules we've got permitted earthworks and vegetation clearance rules, many requests for additions to that. We agreed where there was a low likelihood of effects arising, that threshold being exceeded, and there were some things that are quite obvious, like an effects for stock exclusion, yeah, fine. And then there were some other things we had to add a little bit of additional weighting where if those supporting policies and whether they're critical for health and safety. Plantation forest activities. So now we've amended so that the focus is only on reforestation. So that means new commercial plantation forestry. So if it's a new area, you'll need consent for it. So it removes the previous rule, which was basically covering all plantation forestry activity. And in our view there, correct me if I'm wrong, Jerome, is that you just rely on the ES to regulate those activities. The district planning should only be concerned about new forestry within the.
So the NES covers existing forestry, does it?
Yeah.
So you're saying there's no need to write a rule about existing forestry because the NES covers that.
Correct.
But is there a gap that requires a rule in the district plan for new forestry, or is it just?
So in these overlays, we're managing it more stringently, so discretionary and non-compliant activity for new plantation forestry. Elsewhere, it would be managed through rural zones primarily. In some instances, I think it's primarily permitted. But in terms of managing those ongoing effects around earthworks and stuff like that, we rely on the ES because it does the job. And as been sort of said, there's only circumstances when you can be more stringent, and that is in relation to say natural landscapes or coastal environment. More generally, just rely on ES.
Okay, thank you.
One of the issues is around quite a few submissions around some thresholds around earthworks and vegetation clearance. This is an issue that Malene looked at and contended with. And she can talk a little bit about that. She's got a slide or two about that. One of the issues around this is the time frame thing. So you were saying that it sort of had over the life of the plan was kind of the time frame. We've suggested, well, that was a bit fuzzy, so let's going to do something like that, just say within any 10-year period. But then you've got this balance of like over 10 years is a long time. From a compliance point of view, that's really, really challenging, actually determining compliance. However, at the same time, if you were to take, so say if you're over 10 years, if 500 square metres was an allowable area, if you were then to break that down into a yearly amount, 50 square metres, there's then a question around you're removing some flexibility there. Because if it's 500 over 10, it provides flexibility to someone to, they might do 50 a year or do 400 in 1 year, a lot more flexibility rather than a 50 year by year. So for us, it was a bit of a balance of wanting still to provide some flexibility for people, but at the same time, helping out the compliance team, because over a 10-year period is harder to prove that non-compliance. So that was the challenge. Malene's going to talk about height and area thresholds in a couple of slides' time. Colour standards were another thing that attracted a bit of attention. So the recommendation there is to remove the reference to the resine colour colour reference, and to bring a more generic one and actually to bring it into the plan as an appendix. Also, the recommendation is for it to apply to new buildings. So that means that it would now not apply to if you're putting on an additional or an alteration to an existing building. We thought that was possibly a step too far. If you've got an existing building and it's a particular colour that looks a certain way, to then restrict the additional or the alteration to only that colour, we thought was a little bit too restrictive, given that you already have the primary building there in the colour that it is.
Can I just ask another question on that, please? The colour change you mentioned is going to be an appendix to the plan, so the reference would be
Correct, as an appendix.
Okay.
Well, then people will have a link to it. So it'll be in the same way that you currently can click on the reference to the colour chart and you go to the resine.
Yeah.
Rather than doing that, you'll go to the BS 5252, which is not resines.
Right.
It's a British standard.
So it won't be an appendix in the plan, it'll be by reference to that somewhere in there.
I don't know, Heather.
And
The links work.
Either option works really. Generally, for longevity, to be in the appendix might work better, just to know where it's there and it's more certain, it doesn't change over time. Or
so this would be a dynamic colour palette, wouldn't it? This would be a dynamic colour system.
It will be as produced in the appendix to my report.
Right, okay, so then it would be fixed.
It's fixed,
Right.
yes.
And having it as an appendix, I mean, this is obviously a rule in the plan, and then having a rule refer to an appendix, does that still make it a rule?
Yeah, it doesn't change it. Yeah, and in essence, it doesn't, from a rule perspective, it doesn't, that reference to that colour palette, whether it's click a hyperlink and takes you somewhere else, or it's an appendix in a plan, you can't update that, even if it's a link, you can't, if they update that, the rule itself has to be fixed in time. Yeah,
So that,
so you can't,
yeah.
So you
can't
can't
have a
update
dynamic
this
rule.
thing.
Yeah.
Correct, so it's fixed in time, and whether it's a link or an appendix.
Right,
And it's
so,
more down to usability and that kind of thing.
and so just to avoid me getting the wrong end of the stick, there's two references to appendix, there's the appendix in your report, there's excellent, but there's going to be an appendix in the plan.
That's what I've recommended.
Okay, maybe we should change this to attachment then, I like. So the appendix will become an appendix. The appendix to Ms. Absalom's report will become an appendix to the plan.
Correct.
Yeah.
Thank you.
And fixed.
And fixed, we have no choice.
So yeah, so that, the colour palette as of the day the plan is, well, is approved, or the day you wrote the report, whatever applies, that's going to be the colour palette that'll last unless there's a change to the plan.
Correct, and assuming you don't get an appeal that wants to challenge the palette for some reason. Yeah,
Okay, just to be really annoying, is it the appendix of your plan, your report? The palette change is between now and the day the plan becomes operative?
It won't. A British standard is a fixed
Okay.
thing. It would have to be a new British standard for it to change.
Oh, it would be another standard, it would have another
It
number.
would have another number.
Right, thank you.
So it is fixed in time, as it were. And it's also the one that's been referred to for donkey's ears, so it has been static for a long time.
Okay.
Thank you.
No, thank you for clarifying that. Good.
the last thing here with the rules is the subdivision within the overlays. We're again sympathetic to the submissions that said, look, you should only be concerned if you're creating an additional allotment within the overlay. So they were concerned that, say, for example, you had a site and a corner of it had a bit of R&L on it, and even though you weren't creating an additional lot there, you were going to get caught by the rule. And so definitely sympathetic to that. Hence the changes, recommended changes there. Right, I'll hand over to Malene.
Which way am I going, right?
You go right.
Right, thank you. Okay, so my report is in 3 sections. The first one talks about mapping. The second one talks about changes to building controls and heights and so forth. And the third one is a collection of other items that these two guys found for me to have a look at. So that's just the structure of my report. So I'll start off with that first section, which is responding to those submissions who have asked for changes to the mapping of the overlays. So just to give you a bit of background, the overlays all come from the Northland Mapping Project, which was Regional Council study a few years ago, and they're included in the NRPS. The RMA requires the district plan to give effect to the RPS, so that's the starting point as far as I'm concerned. The Regional Council has mapped these things. They have provided that information to us. We can make changes to that so long as we go through an assessment methodology that is defined in another appendix. This one's an appendix to the RPS, just to add to the list of appendices. In terms of those individual requests for changes on particular properties, I did a very careful assessment of the overlay area with both the PDP maps and with Google aerial photography. I was able to supplement that with Google Street View to assist understanding that, but obviously Google Street View is only the street view, and some of these properties are very large. Where necessary, I undertook site visits to confirm the situation on the ground, particularly if I found that the information on one lot of maps was quite different from the information on another. I needed to be reassured what was actually happening on the ground. And as I've explained in my report, we are dealing with different data sets here. Obviously, the regional council used one lot of data set for creating its maps. That's then been translated into the proposed district plan. Some minor mismatch is likely when you're dealing with different data sets like that. And the appendices that show where I'm suggesting some refinement of the boundaries of one of the overlays, quite a lot of them are, I think, in this category. They're a small mismatch that has occurred between one lot of data and another. It wasn't an intentional, yes, we want to grab that bit of land into the overlay. There are others where that doesn't apply. So in responding to those requests for changes, I looked at the assessment criteria in Appendix 1, which are the same criteria that came from the mapping project, so they've been rolled over from the RPS. Something I was aware of was that there are big differences between ONLs, which generally are fairly large areas of land. They contain all sorts of things. Quite a lot of native vegetation, but also roads and buildings and houses and gardens and so forth. Whereas natural character areas, HNCs and ONCs, tend to be exclusively vegetated. Not entirely, but they tend to be exclusively vegetated, and they tend to be much smaller areas. They've been picked out because of the value of that vegetation. That's why they are ONCs or HNCs. That difference is actually quite important when thinking about some of the submissions that have come in about them. So buildings, gardens, lawns are unlikely to be found in ONCs, but they are found scattered with ONLs, where the landscape is, the scale of the landscape is such that the overall character is not undermined by the presence of these more man-made artefacts within it. And I just note that there were fewer requests to remove the coastal environment from individual properties than to adjust the other three overlays.
I can I have a quick question about those general categorisations. So where would a cultural landscape fit?
A cultural landscape can fit anywhere. It is not identified as an overlay in the proposed district plan, but Tāmata Whenua particularly are in a position to advise where cultural landscapes exist. There are, in my view, European cultural landscapes as well. So, for example, Waitangi is a nationally important cultural landscape, not primarily because of its importance to Maori, but in association with that, but also it was the European Maori interaction that creates that cultural heritage value at that place. But it's not something that is mapped within the proposed plan.
But it could be a component of ONL and ONC, or more one or the other. I think the NZCPS gives you a little bit of guidance on that as well, where it talks about cultural components.
Yes, certainly it invites consideration of that. The Northland Mapping Project endeavoured, particularly I think in the Outstanding Natural Landscapes component of it, to seek input from Māori as to where their preferences might lie in terms of fire protection. But my reading of the assessment sheets is that they were not in a position to have feedback sufficient to enable them to incorporate that into the ONLs that they identified.
Right.
That doesn't mean that that cannot happen now. So if, for example, someone wanted to come forward with either a development proposal or a subdivision or whatever, the identification of cultural values is always available to be done at that time so that that can be recognised. But it isn't currently recognised in any mapping sense within the plan.
Yeah, if I may, so just so I'm clear, the NRC mapping and assessment has just come through into the district plan. There's been no new assessment.
No, there's been some refinement by me, but no new assessment.
New, so no new exercise of identifying new ONLs, for example. And so Appendix 1, I'm just looking at that now, it does have one of the criteria as being spiritual, cultural, and historical association. So when they did that, what you're saying is when they did that NRC work, that was a bit of a gap in that.
Sorry, which bit of Appendix 1 are you looking at? Is that the landscape assessment criteria?
Mapping methods and criteria, yeah, outstanding natural landscape identification and assessment criteria in the plan. Appendix 1 of the plan, of the PDP.
I'm looking at the Appendix 1 from the district plan, which may not be exactly the same. I'll just get my secretary to find it.
So Appendix 1,
It's got the first table.
they're pretty much,
I think they're okay.
they're identical. The last one is experiential values, it's spiritual, cultural, and historical.
Yes, you are right.
That's there. What you're saying is when they did the NRC work, they didn't really engage with that.
They engaged with it in the sense that they invited input. But my reading of the individual worksheets is that they got nothing back that they were able to utilise. But that's my interpretation of what the worksheet says.
Yeah, okay.
I may be wrong. I wasn't involved in that process.
And this was all done prior to Tangi Ata Manu coming out, not through
Yes,
the
yes.
Island? Yes.
This all precedes that.
Yeah. And that's not a problem? It's the gap, kind of?
My interpretation of the work undertaken for the NRC is that they were pretty much in line with the new methodology that the Institute encourages to be used. They're certainly not a long way apart.
Oh, well, I think we'll leave it there. We might have further discussions about it. That's good, a good intro. Thank you.
Okay, I think we've got another question from one of the commissioners.
Thank you. I just had a question about timeframes because there wasn't a timeline in the mapping methodology to associate when the mapping was done for the RTS, because that would have been done before it became operative.
Yes.
And then now we're currently in 2024. So there would have been, you know, a lot of people still carry on and do modifications that are, you know, usually people aren't aware of when the property's been mapped or not. Can I just understand that so that I can gauge the amount of time between when that mapping was done and current day?
In terms of timing, I'm just doing a quick Google now, but the architect just going through my brain, the mapping was probably done about 2012-ish, would be my guess. I'll just confirm that, but would have been around about then.
So there's been 10 years, so 12 years of time between that mapping and the current day.
Yes. Yes.
And so
This is one of the difficulties we face with the process we're in. I mean, the PDP was being prepared 5 years ago, there is, the speed with which these things develop always means that something is going to be becoming out of date. I mean, that is the reason why the RPS says that this is what we've mapped, but local authorities can go through a process to update that information. Because updating is necessary because time goes by.
So just to clarify your role in the methodology of this mapping, we've utilised the NRC data. You've only ground truth people who've made submissions, no other assessment of the differences between 12 years ago and now has been undertaken for the mapping.
That's right.
Other than those that have made submissions.
That's correct.
And our role is to consider the submissions and consider what changes, if any, should be made in response to the submissions. So that's our role is limited to that. Our role is not to necessarily critique the process that was underdone or the mapping that was done, etc. We are looking at the submissions and the challenges that have been raised in the submissions. And as I understand it, I'll leave it there.
And I just wanted to understand the resources from that may or may not, in this case, have been put into ground truthing mapping changes between you.
Thank you.
Okay, so moving on to my next topic. Not moving on to my next topic. What am I pointing at?
Over here, I think.
Over there.
I can do it for you.
If you put them here,
No,
you can't do it.
He's going to sleep, isn't
it does seem to go to sleep. Here we go.
Thank you. So moving on to the second topic within my report, which is about almost development controls. The notified plan applies different height and coverage controls to different places, depending both on the zoning of the location, the type of building that's being proposed, and the presence or absence of one of the 4 overlays that we're talking about today. From my review of the proposed plan maps, there are 14 different scenarios, which is incredibly complicated, of a mixture of zone and overlay. So what the authors of the proposed plan did was to simplify things rather than having those 14 different controls. They've simplified things as far as possible. I think probably in a general sense what our response to the submissions has been is to make it slightly more complicated, but nowhere near as complicated as those 14 mixtures might suggest. So from a landscape perspective, the introduction of new buildings is more likely to cause adverse effects if it's in one of the overlays rather than if it's in a rural area. And if it's in a rural area rather than in an urban zone. One expects new development to be occurring in an urban zone. It is more unusual, it's not rare, but it's more unusual in a rural zone. In my view, it's also important to think about the type of building. Dwellings tend to be more complicated in design and to create around them a domesticated landscape. So if you see a rural perspective, it's usually possible to say that's a barn and that's a house, because visually they are different and they associate, and dwellings have associated with them the curtilage that has washing lines and sheds and driveways and parking and all the rest of it. And that can be a problem in some of the overlay areas. And that's why that distinction between dwellings and non-dwellings is made within the rules. Work that time. The permitted site coverage and the maximum building height standards were pretty restrictive in the proposed district plan. They were appropriate for some situations, but they have been used more broadly than we decided was appropriate. And so some relaxation of those is being enabled in our recommendations. The natural character values of a number of the district's coastal settlements has, in my view, already been impacted by existing development. And in those settlements, maximum building heights of existing buildings already far exceeds the building height that was being imposed by the Coastal Environment Overlay. And therefore, we have proposed that those be relaxed for those settlements and for the non-residential zones within those settlements. So that's primarily mixed-use zones, but it also includes some of the industrial zones as well. In the 6 of the larger coastal settlements, it's proposed that the underlying zone permitted heights will prevail for non-residential areas. In other overlays, for example, the ONL, non-residential building footprints have also been increased. So in ONLs, we're increasing from 25 square metres to 50 if it's in the coastal environment, and to 100 square metres if it's outside the coastal environment. That's because there were a number of submissions that pointed out that 25 square metres it's pretty flipping small. 5 metres by 5 metres, it's a double garage. And a small double garage. So we have accepted that particularly farm buildings and similar sorts of things may well need to be bigger than that, and therefore we've increased those footprints. We're not saying there don't need to be any controls at all. We still think there should be some controls if you want something very much bigger, but that's just one example of how you've increased the building footprint size.
If I may just ask a question on that, while we're at it, how did you come to those numbers? Was there any science to it, or was it just kind of your gut feeling?
The gut feeling, I think, is the right response. It's a good understanding of what those different size buildings look like. I'm sufficiently familiar with small buildings to know what 100 metres looks like. And a pretty good understanding of where they might be occurring, the sorts of situations that they might be required for, the sorts of situations they might be seen in, to gauge where they can be. I mean, wherever you draw the line, somebody's going to be inside it and somebody's going to be outside it. That is always the case with any sort of measurement limit you place on anything. And people will argue either side of that, but I think they are reasonable figures.
I think you've just explained that it's not a gut reaction. You've had quite a rational explanation. Did you actually look at any statistics from council though? Because I know Far North District Council processes a lot of applications for, 25 squares for buildings and ridiculous things that all get approved anyway.
No, I didn't look at any statistics.
Right. Okay, thanks.
The corollary of that is, did you have regard to any sort of functional methodology in terms of, like for farm buildings particularly?
Yes, certainly.
Two tractors and a trailer or a combine.
Certainly federated farmers.
Yeah, but that came through in their
they came to, yes. So I had that information available. And I am a rural property myself. We have a tractor. I know the sorts of sizes that these things need to do.
Well, it seems to me that your gut's quite rational then.
I just have a question to align it with the legislation relating to exempt works for buildings, to Schedule 1 of the Building Act. For rural buildings, it's up to 110 square metres.
Right.
So you didn't look at any of the Building Act exemptions for farm buildings?
No, I didn't.
Well, thank you very much, Sam. Thank you for those answers. Please proceed.
I think it's back to you.
Oh, that's
Sorry, one thing I was going to say, it's not included in the slides, but I was prompted to recall it when Ben was talking. You will see in my report that I have a particular concern about the combination of earthworks and vegetation removal being combined, and I explain why in my report. I am well aware of the fact that the proposed plan has them combined and there aren't any submissions seeking for them to be separated. But it was important from my perspective to make you aware of my thinking around those two matters.
Can you just summarise again what that was without us having to go back to your report?
By all means. It's probably as a result of 30 years of living in the Ōmāpere ranges, but I am aware that people undertake earthworks when necessary. They're expensive, they make a mess, they take time to recover from. People undertake vegetation clearance, in my view, at the drop of a hat. If you allow them to do so much per year or so much per 10 years, or it doesn't really matter what the time frame is, there are those people who will keep doing it until they've got rid of all the vegetation they don't want. And that may be vegetation that is important for either landscape values, or natural character values, or coastal environment values. And I find the ability to remove that vegetation readily difficult. But I acknowledge that that's what the proposed plan proposed, and that there aren't any submissions seeking to separate them.
Okay.
Just one question on that, Malene. In terms of what you've presented though, are you limited by what's in the submissions? You've not gone beyond what the submissions seek?
Well, I've gone beyond in terms of giving my perspective, but in terms of what we're recommending, no, we're limited by the submissions.
Thanks.
So notwithstanding your concerns about those issues, there's not scope to...
I didn't make a submission to the
We have submissions raising concerns about the rules being applied over a 10-year basis.
Yes.
I was going to say, if we were, if we were to agree with Ms. Absalom's concerns and resolve to try and write a slightly different rule framework, have we got the scope to go there?
Obviously, yes.
You can take some time to consider this, double check. But.
Yeah, there's certainly submissions seeking a wider range of belief on the earthworks and vegetation clearance thresholds, so I believe there's scope for submissions to...
That might be something that we might just sort of clearly set out in your response.
Yeah. We won't be the people standing up at the environment. We just wish you luck.
Okay, is that the end of your presentation, Ms. Absalom?
It is.
Thank you very much. Has any other council officers got something to add?
We're back.
We're only partway through.
Slides.
Oh, right, okay, sorry. I thought,
So we'll scoot through. So just some particular issues.
been asking too many questions.
Yeah. Some particular issues, recommendations with particular chapters. So with the natural features and landscapes, we've got both a policy and a rule here around farming. Yeah. The policy was about recognising farming, and then the rule was around to control new farming. The recommendation here is actually to broaden that policy, not just to farming, but to all existing activities, and that comes back from that RPS method that I talked about. So I think that's important. And then looking at the rule itself, ultimately we thought that there was actually very low risk of new farming activity causing undue adverse effects on O&L and O&E. Firstly, because of the type of existing land use that's already there and the type of land that's there. And secondly, you've already got a bunch of rules controlling vegetation clearance and buildings, etc., that give you an element of protection anyway. Also had some difficulties around that existing use rights issue. existing use rights are limited. If you've got a change in character or intensity or scale, that you then don't get the benefit of that. So if you're a farm and you wanted to say plant some avocados or do some cultivation or something like that, then you're potentially going beyond that change in scale, etc., and therefore you couldn't rely on that, and therefore that activity would need a consent on your existing farm. The combination of that, the recommendation was, let's delete that rule. Lakes is an issue around how do you define a lake and when does the rule sort of trigger come in. The notified plan included all lakes, so any pond, so the RMA definition basically captures any little puddle or pond or little bit of water body, so you need to, I think, have a threshold when the rules kick in. So my suggestion here is that we run with 1 hectare as being a and sorry, I've got, it says less than, it should be lakes greater than 1 hectare. And also, if it's an artificial lake used for stormwater attenuation, that's exempt. Wastewater treatment ponds exempt. The challenge is around water supply dams. So in some instances, they actually have natural character values, and some instances they don't. And it's really hard, but I'm not aware of an easy, clear way of differentiating that. Now, the 1 hectare threshold will help get rid of a chunk of them, but there will be some that don't. And yeah, that's the challenge of trying to draw a line around these things. So just to make you aware of that challenge. Back to Drone.
Yes, just briefly on some of the issues specific to the coastal environment chapter. Elaine's kind of touched on it, but one of the key concerns is really the approach to the coastal environment, how it applies to urban areas, and concerns that this is overly restrictive and too blanket and didn't really recognise the different nature and built up urban areas in the coastal environment. And also the definition itself of urban zone was problematic in that it does not capture all the zones. So I'm recommending amendments to the objective and the policy that relate to urban areas. So it's not so much about protecting the status quo, it's more recognising that some change in character may be acceptable in these urban areas to provide for well-being. As Elaine sort of touched on, we've recommended the rules take a more nuanced approach. So in those more built-up urban environments, you rely on the underlying zone rules for the building size and height outside residential zones. And I'm also recommending removing the reference to urban zones and just more targeting on the zones where for permitted activity standards. A similar issue around the policy direction for farming activities in the coastal environment. It has some direction that would potentially conflict with some of the avoid policies. So I'm recommending removing that and instead capture the intent, which I think is to really recognise that farming activities form part of the coastal environment and allowing those existing activities to continue without undue restriction, recognising the policy direction RPS, which specifically talks to that, and also to sort of enable new farming activities, but it's outside those outstanding and high natural character areas, which is supported by a rule in the chapter. And as Melina said, we've sort of also refined the rules as they apply outside urban areas, so it's taking more of a threshold approach based on the underlying overlay and targeting rules to restrict building use for residential activities.
Just I think we've got a question here.
I've just got a question about one of those points about direction for farming activities, and it relates to what Ben brought up regarding the definition of a farm dam and if it's excluded or not. You can't have a farm without water.
Yeah.
I'm sorry, I need to point this out, but based on the farm dams not actually having a definition and if they're captured or not, how that really needs to be addressed if farming is to be enabled as a definition.
So the PDP has a definition of farming, and the purpose of that definition is to sort of differentiate it from the wider definition of primary production. So it excludes things like mineral extraction and plantation forestry to sort of recognise that farming may be more acceptable in some areas. In terms of farm dams, I haven't really considered that as an issue, but it's certainly something we can think about around how that might potentially be enabled or disenabled through some of these rules.
Yeah, just to point out that I think that's a big issue, whereas every single farm in the coastal environment would need reticulated water supply and troughs.
Yeah.
There's a lot of farms that have dams.
It seems that that's a really tricky issue because you're going to bump into section 14 at some stage. And possibly some regional rules.
Yeah.
Is there any guidance on the RPS as to what is or isn't sort of like a human-made structure for
I think so.
farming, for holding wood for farming, as opposed to what is a natural water body? Often, a lot of these farm ponds are fed by some form of overland flow into them. That's why you put them there.
Mm-hmm.
So I'm just sort of wondering, this sort of potentially starts to devolve into quite a hornet's nest of, and then you've got some NES, freshwater matters that might kick in as well.
Yeah, we might have come back to on that in terms of the regional rules. Certainly, you know, the broader rural environment, the sort of earthwork provisions and things like that are quite enabling on rural activities and,
Yes.
but we're in the section of regional rules. And,
It might be that you're permitted to dig the hole,
yeah.
but you might need a section 14 consent to fill it, particularly, and then you might end up diverting something that might be classified as a stream at some point somewhere else.
But by default, that means that farming, all farming needs a resource, since that was the basis of the land.
It might just be that the plan is, if there are a number of layers above that control all these things, notwithstanding what you want to do in the district plan, it might end up being that you stay silent and let the other instruments handle it, because we can't change them. I suppose what we want to know is what other instruments are influencing that particular thing. If it becomes permitted, is it going to get triggered by something else? And maybe that's the better way to deal with it.
So I can respond to that a little bit.
Yeah.
My knowledge of the regional plan. So the regional plan includes rules for dams and both in-stream and off-stream dams.
Right.
And off-stream dams, i.e. ones that are just collecting water off the landscape, not within a stream, are permitted activities.
Right.
There's some constraints around that, size, etc. But generally for a farm scale, you know, typical dam, it's a permitted activity on the regional plan, and to use and take and use that water as well.
Right.
On that dam. Yeah.
So it might pay to sort of try and look at that, those definitions and try and align with them, maybe, or just rely on those.
Last slide for these three topics, and this is just really to provide a very high-level snapshot of some of the outstanding issues based on pre-circulated evidence.
Yeah.
Obviously, you're going to hear through from submitters and experts throughout the course of this hearing and additional issues that we raised, and we will respond to those as appropriate through our reply. But just really quickly, there's some zone specific concerns in relation to Waitangi Treaty Grounds, Okua, Matoti Bay. Some concerns around management of vehicles on beaches, some requirements for the control activity rule for buildings on approved building platforms, the kind of activity status that Ben talked about earlier around when compliance isn't achieved in the ONC, ONL and ONF overlays. Mapping methodology, you'll hear today about some concerns around the relationship of the infrastructure chapter and that not being clear, and also some concerns around the workability of the new rule we're proposing for upgrading of network utilities. Some additional requests for exemptions around earthworks and vegetation clearance. Mr. Riddell, you'll hear from him tomorrow. He's requested a range of amendments to the provisions. Some outstanding issues around the colour and reflectivity standards. I think this is more around interpretation rather than some differences in opinion and intent. And some requests for additional mean high water setbacks. And lastly, some concerns around the use of the term minimum necessary in terms of earthworks and vegetation clearance, both in relation to the natural character chapter and Indigenous biodiversity. And that's kind of the end of that topic. Got any more general questions? Or...
So would we move on now to ecosystems and Indigenous biodiversity? Is that the plan?
That's the plan.
Or maybe we can just pause for a couple of other, see if there's any questions associated with those three topics first. I know we've asked quite a few questions already. I'll see if there's more of a structured response. Any further questions about those two topics?
Yeah, I've got quite a few. I'm just conscious of time.
Well, I think we're sort of doing okay. How much time do you think the biodiversity explanation requires?
A lot quicker than me.
Well, sort of, I mean, if we're going to be strict to the timetable, we're probably got about 15 minutes.
We do have Mr. Fisher on.
Yeah, so I also wanted to spend a little bit of time on that sort of legal issue.
Okay.
Yeah.
And we'll come back to this if we need to.
We can come back to it. Yeah.
So we don't come back to it for these questions.
Yeah. Okay, in that case, we'll move on to our final topic.
Okay, so biodiversity. As you will be aware, this is quite a controversial topic for the district plan. Huge number of submissions received, 700 submission points, almost 1,500 further submissions on those submissions. Generally, submitters oppose the chapter, but often for quite different reasons. And a range really sought on changes to the provisions, but also boiled them down to three key overarching themes. The first is the approach to give effect to higher order documents, in particular the NPSIB and the RPS. The approach to identifying, mapping and protecting significant natural areas, if we want to use that word. And just generally requests for the provisions to either be more stringent or to be more permissive. Also some more specific concerns around recognising the role of Tangata Whenua and Kaitiaki, and concerns about potential restrictions on the use of Māori land. Large number of concerns around the potential controls on dog ownership and controls on pests, and a wide range of issues raised in relation to the Indigenous vegetation clearance rules and the associated thresholds and exemptions that apply to those rules. So the first main issue I address in my report is giving effect to the NPSIB. So obviously this came into effect in August 2023, so about a year after the PDP was notified. As I said, Mr. Fisher's online, he's going to talk to some of the more specific legal issues around the obligation to give effect to the NPS as soon as reasonably practicable. So really just some key conclusions. I've done an analysis looking at where it is practical to give effect to the NPSIB. In short, I conclude that it's not appropriate or practical to give effect to most of the NPS provisions at this point in time for a whole range of reasons, but that includes the provisions relating to SNAs. It requires those areas to first be mapped, and doing that requires a dedicated program of work, and it requires collaboration and transparency, best practice principles, etc., which is not practical to do through this process. There's also a whole range of provisions in the NPSIB that direct further engagement on technical work, for example, working in partnership with Tangata Whenua to identify tonga species. Again, it's not practical or appropriate to try and give effect to those provisions through this process. However, there are some provisions in the NPS that are more general in nature, and it is practical to give effect to them without significant amendments to the PDP or causing natural justice issues. So, for example, the direction relating to taking a precautionary approach where there is uncertainty but potential for significant adverse effects. So the second main issue, obviously a key one, is around SNA mapping protection. So some of the complexity and contentious nature of this issue relates to the fact that the draft district plan was notified of draft SNA maps, which I'm sure you're all aware. A significant amount of opposition to those in terms of the process that was used. So there was a decision made to withdraw those maps from the PDP, resulting in somewhat of a kind of voluntary case-by-case assessment to SNAs, which was notified in the PDP. A whole range of issues have been raised with this approach. That includes the fact that it's not meeting obligations under Section 6C, that it's shifting the responsibility for identifying these areas from council to landowners, that the requirement to undertake an ecological assessment to prove the area of bush is non-SNA is unfair on landowners, that it creates uncertainty around the application of rules that essentially relate to unmanned areas, and also the risk of a lot of inconsistencies and rework when you actually do a full district plan mapping approach. So my recommendations are essentially to remove all references to SNAs from the district plan and replace that with wording in Section 6C, and amend the definition accordingly, to delete those policy directions relating to identifying SNA mapping and Schedule 4, which is empty at the moment, which would be the SNA schedule. And at this point in time, just better align the fixed management policies with the RPS until such time as a future NPSRD plan change is initiated. Just very quickly, there were some other issues that have been raised. As I sort of said, there's been a lot of requests to better align with RPS policy 4.41, which is the key provision RPS. So I'm recommending amendments to policy 2 and 3 to do that. New direction relating to better recognising the role of Tangata Whenua as kaitiaki, and some more flexibility in Rule 2, which relates to residential units on treaty settlement land and multi-purpose zone land, so a bit more flexibility there. Some refinements to policy 9, which is about clarifying how restrictions on pet ownership or pest ownership might be applied, and that's through consent conditions only as necessary to protect predators and their species. I'm recommending a new sort of policy direction which recognises there are actual other mechanisms to protect and restore biodiversity, for example, environmental benefits subdivision rule and subdivision chapter. In terms of Rule 1, so this is this long, rule which essentially permits clearance associated with certain activities, so a lot of requests to be added to that list. I'm largely recommending that is refined, review refinements and also addition of clearance for the purpose of upgrading infrastructure there. Rule 4, which is now Rule 3 of my recommended amendment. So this is the indigenous vegetation clearance that apply more generally, different thresholds for urban type areas versus productive areas. What was notified was essentially 5,000 metres permitted over a 5-year period. I'm recommending we bring that down to an annual year threshold and down to 500 metres squared. And that partly relates to the decision not to map SNAs means you sort of have to be more protectionist generally. And lastly, Rule 5, which is a rule for plantation forestry and unmapped SNAs. It didn't make sense to me, so I'm recommending removing that, relying on the ES commercial forestry at this point in time, and potentially giving effect to this direction in NPSRD specifically related to plantation forestry, so give effect to it through that future plan change process. So you just a quick snapshot again of outstanding issues based on pre-circulated evidence. Again, there seems to be some broad level of support for the Section 42A report recommendations, but still some remaining issues in contention, and that again relates to the relationship with the infrastructure chapter, some refinements to the policies, a need for much more of a partnership approach around how to develop these provisions with Tangata Whenua, some outstanding issues around the Policy 7, which relates to the control of pests and the definition of pests. I'm recommending that be too limiting. The reference to minimum necessary is discussed in the earlier slides, and again some requests for additional exemptions to the permitted activity thresholds, and some outstanding issues around the Rule 3 being both too permissive and too restrictive. And it might be time, I'm happy to take questions now, but also might be time for Tim online if you want to.
I think we'll proceed to Mr. Fisher, and then we'll see where we get to at the end of that.
Do you want me to stop sharing, Jerome, or keep it on?
Stop sharing.
Stop sharing. We can see Tim.
Well, good morning, Mr. Fisher. Can you see and hear us?
Yes, I can. Good morning, Mr. Chair, and good morning, Commissioners. On Friday, I did file some submissions and a memorandum, and I will share that with you and step through it. I'm conscious we've got 7 minutes left until the scheduled break. Would you like me to, I'll try and step through this as quickly as I can. Would you like a hard stop at 10:30, Mr. Chair, or perhaps we play it by ear and see if we're nearly finished? I just don't want to interfere with the break too much. How would you like that to play out?
Oh, I'd like you just to present your submissions now. We can be flexible with regards to the break, and we might just take the break at 11 rather than 10:30. So just present your presentation as you would, and we'll see how we go.
Right, thank you for that. So I'm sharing the screen. Can everyone see the memorandum there?
Yes.
And is the size okay?
Yeah, could you make it as big as possible?
Yeah, I'll try and.
If you can fill your screen with it, because it's only taking up 3/4 of the screen that we're looking at.
Right, okay. Let's see how it looks.
Oh, that's good. Although we haven't quite got all the text, but.
No, we might have to go down one, which makes quite a bit smaller actually. If I'm going to, yeah, that might be the best I can do, sorry.
A little sorry to the people at the back, but there's a bit of glare on the screen and we're really sort of struggling to read. Yeah, that's so much better. Right, we good?
Sorry.
Okay, thank you.
So I start here with my introduction, and the first few paragraphs are just setting out the timing and the background, the notification of the PDP and the timing for when the NPS IB came into force. So in paragraph 3 there, the implications of that are that the Schedule 1 process was mid-flight when the NPS IB came into force. The NPS IB came into force sort of about a year to a year and a half after the notification of the PDP. So that timing is quite important to explain why we are where we are in terms of giving effect to the NPS IB through the PDP. This memorandum addresses the extent to which decision makers on the PDP are required to give effect to the NPS IB when making decisions on submissions. And the memorandum is filed in support of the overall approach to the NPS IB in Mr. Wyeth's Section 42A report. In this section, I just set out the well-known requirement to give effect to higher order planning instruments, in particular national policy statements, and that arises under Section 75 of the RMA, of course, which will be well known to the panel. In these next couple of paragraphs, I just set out what giving effect to means, and I don't think I need to dwell on this too much. It comes out of King Salmon, and it's been well understood and well studied since that case came out nearly 10 years ago now. So I won't dwell on that too much. Effectively, you've mandatory and directive requirements must be given effect to, and that means positive implementation through the district plan. At paragraph 9, I note that while some efforts were made to align the general direction of the notified PDP with the direction of the NPS IB exposure draft, being mindful of a fair amount of uncertainty about what the final NPS is going to look like, the PDP does not fully give effect to the NPS IB because it was publicly notified before the NPS IB came into force, as I've explained in the intro. The NPS IB includes a number of highly directive provisions for the management of Indigenous biodiversity which must be implemented. However, the question of timing arises, particularly where we've got a Schedule 1 process which is mid-flight. So the timing requirements in the NPS IB are set out in clauses 4.1 and 4.2. Clause 4.1 requires every local authority must give effect to the NPS IB as soon as reasonably practicable, and that's those are really important words which I'll come back to later, and they're the tests that we ultimately need to apply at this point in time. This in paragraph 12B is a timing requirement that applies to NPS IB generally. Local authorities must publicly notify any changes to their plans that are necessary to give effect to the NPS IB within 8 years after commencement. So that's 4th of August 2031 as the NPS currently reads. The NPS as it currently reads has a tighter timeframe for the SNA provisions. So clause 4.2 requires local authorities to publicly notify any plan or changes necessary to give effect to subpart 2 of subpart 3, which is the SNA provisions and the information requirements within 5 years after commencement, so 4th of August 2028 in that case. So that's how the NPS currently reads, and I get on now to proposed amendments to the timing requirements, and everyone will, of course, recall election commitments of the current government relating to the SNA provisions and in particular the timing of those. So there is a bill currently before Parliament to amend the timing requirements. It had its first reading on the 28th of May 2024 and it will implement the government's announcement that requirements for identification of new SNAs will be suspended for a period of 3 years. And in terms of how we're tracking through that process, submissions on the amendment bill closed at the end of June, and the Select Committee will report at the end of next month, end of September. The parliamentary process is likely to conclude in late 2024 if it keeps tracking the way it is. In terms of what those amendments say and what's proposed, although wider reform of the RMA and potentially the NPSIB is on the government agenda, the amendment bill proposes relatively discrete changes to disapply key requirements for the identification of SNAs and district plans. And it also disapplies the clause 4.1 requirement to give effect to the SNA provisions as soon as reasonably practicable, which is the test which currently applies under the law as it stands now. These provisions are proposed to be disapplied for a 3-year period, which commences when the Amendment Act comes into force, assuming it does. The clause 4.21 requirement to implement SNA provisions within 5 years is proposed to be extended from 4 August 2028 to the end of 2030. But some other provisions unrelated to SNAs remain subject to the 5-year timeframe. Some provisions in the bill. Clause 4.1, which is the requirement to give effect to the NPSIB as soon as reasonably practicable, continues to apply in relation to other provisions on the NPSIB that's explicitly provided for. The changes in the bill do not affect any functional requirement under other provisions of the RMA relating to Indigenous biodiversity, including in relation to areas of significant Indigenous vegetation or significant habitats of Indigenous fauna. So the Section 6 matters of national importance. An SNA included in a proposed plan after commencement of the Amendment Act is not to be treated as an SNA, regardless of how it is described in the plan for 3 years from commencement of the Amendment Act. So in terms of what those things mean in practice, the proposed changes do not remove the Council's obligation to give effect to any IB provisions which are unrelated to identification of SNAs. The proposed changes do not relieve decision makers of their function to maintain Indigenous biodiversity under Section 31, the requirement to recognise and provide for the protection of areas of significant Indigenous vegetation and significant habitats of Indigenous fauna as a matter of national importance under Section 6, or the obligation to have particular regard to the intrinsic values of ecosystems under Section 7. So none of those things are going to be changed under the Amendment Act. If the amendment bill commences in its current form before council decisions on submissions are publicly notified, that being the date the PDP is amended under clause 10 of Schedule 1, proposed Section 78 would appear to effectively cancel out SNAs included in the PDP through decisions for a period of 3 years from the date of commencement of the Amendment Act. So including them for the sake of discussion, including them through this process would seem to be a relatively futile exercise, putting aside, of course, all the other issues with doing that at this stage, which I get onto later. And this just relates to the timing of the bill and the fact that we're still proceeding through the parliamentary process. So as it stands, it's not law. It doesn't currently have a legal effect. However, the hearings panel must apply the law as it stands when it comes to make its recommendations. And I noted at the beginning of this session, the chair advised that no interim recommendations are anticipated. So if the amendment bill has passed into law at the time of the hearings panel's recommendations, it should be applied by the hearings panel. That means that the requirement for identification of SNAs and district plans and to give effect to the SNA provisions as soon as reasonably practical will not apply. And this position applies unless there are transitional provisions which provide otherwise, and currently there aren't any in the bill. In this next paragraph, I just talk about the possibility of broader change and the uncertainty that goes with that. I don't think I need to read that out in full. We can move on to the next part of the submissions. In this part, I address in more detail the requirement to give effect to the NPSIB, and in particular the timing aspects of that and the relevant case law. The leading case is the case of Southern Cross Healthcare and Eden Epsom Residential Protection Society, which came out last year and has been fairly widely cited since. So I suspect the panel might be already familiar with that decision to some extent. That decision actually related to the National Policy Statement on Urban Development. Although the principles are applicable in my submission to other national policy statements as well. And the decision related to determining whether the NPSUD needed to be given effect to at the time of a plan change, or whether that was not required due to the NPSUD requirements for implementation by a later date. In that case, the NPSUD came into force on the 20th of August. During the Environment Court appeals phase, for that matter, obviously after public notification of a proposed plan change in 2019 and after council decisions on the plan change in May 2020. Despite the NPSUD coming into force when the Schedule 1 process was underway, the High Court found that the Environment Court was obliged to consider the extent to which the proposed plan change would give effect to all provisions of the NPSUD when determining appeals. So in that case, the Environment Court actually erred by not doing so, and the matter was overturned and sent back to the Environment Court. In paragraph 26, I set out the findings of the High Court. Perhaps I can take that as read and move down to the application of that decision to the current circumstances. In paragraph 28, it follows from that High Court decision that clause 4.1 sets an outer limit of 8 years to publicly notify plan changes necessary to give effect to the NPSIB. Clause 4.21 sets an outer limit of 5 years to publicly notify any plan changes necessary to give effect to the SNA provisions and the information requirements. And this is the important finding in that High Court's decision. These outer limits do not defer or diminish the Council's obligation to give effect to the NPSIB as soon as reasonably practicable. So you can't, it's saying a decision maker can't say, oh, we've got the 5-year limit, that's what we're going to work to. This requirement to give effect to as soon as reasonably practical comes into play sooner. In paragraph 29, I just set out there that the normal principles of scope apply when giving effect to an NPS. And I've set them out there in paragraph 29, what they are with footnotes to the relevant cases. They're fairly well known. I think I'll take those as read. And anyone who wants to study them a little more closely can come back to it. the question in broad terms is whether the relief that the panel is contemplating is fairly and reasonably raised in the submissions is the main test, but there are some additional factors that come into it under the paragraphs A through D. So in summary, the extent to which the NPSIB should be given effect to through council decisions on the PDP therefore depends on the scope of submissions and whether it is a reasonably practical time to do so. As noted by Mr. Wyeth, the scope of submissions on the IB chapter is broad and includes several submissions generally seeking amendments to give effect to the NPSIB. So that's certainly the case. However, I just do note here a bit of caution might still be warranted, and questions of fairness may arise if there are wide-ranging changes or changes that may affect people not involved in the process. So we still do need to be mindful of fairness, I think, notwithstanding the wide scope. You know, for example, if an SNA were to appear on someone's property at this stage in the process, having not been notified and not picked up on the summary of decisions requested, there may be a question about whether they've had a real opportunity to be involved in the process. That's just an example. In paragraph 32, I set out some legal commentary on what reasonably practical means. We have here a Supreme Court take on that, a fairly wordy way of putting it, perhaps, but I'll let the panel take a minute to read that. And perhaps a more succinct way of putting it was in Southern Cross Healthcare Limited, the High Court case I've just taken you through. What is a practicable time will depend on the circumstances. That's a very simple sort of summary of it. And of course, the element of reasonableness also needs to be factored in. So that's an overview of the timing requirements in the NPSIB and what they mean under the law. And in this next section, I move on to how it's been approached in the Section 42A report, how Mr. Wyeth has gone about addressing that question of what is reasonably practicable to give effect to now in terms of the NPSIB. The question of whether it is reasonably practical to give effect to the NPSIB provisions through the PDP is addressed in Mr. Wyeth's 42A report. In his Appendix 3, he includes a detailed assessment of the extent to which it is reasonably practical to give effect to the NPSIB provisions. So he takes a sort of relevant provision by relevant provision and sets out in quite some detail to explain his approach. And he also sets out some key principles that have guided his approach, which are there at the top of the appendix. Mr. Wyeth has considered the relevant circumstances as required under the law and concludes that it's not reasonably practical to give effect to the NPSIB in full through the PDP process. His assessment identifies the following difficulties in giving full effect to the NPSIB at this time. Practical inability to follow procedural requirements as part of the PDP process. For example, Clause 3.8 sets out a process for assessing areas that qualify as SNAs. It includes a district-wide assessment, a partnership approach with tangata whenua and landowners, and physical inspections. So it hasn't been done due to the timing requirements. The NPSIB coming into force after the PDP was notified. It hasn't been done, and it's not really practical to do it through this process. Those procedural requirements just couldn't be met. Another practical difficulty, absence of technical work to support new plan provisions. For example, assessments by suitably qualified ecologists. Some clauses have prerequisite procedural steps that have not yet been completed by the regional council. A couple of examples here. The requirement under clause 320 for regional councils to record areas outside SNAs that are highly mobile fauna areas, with a requirement under clause 3.22 for regional councils to assess the percentage of Indigenous vegetation cover and set targets for Indigenous vegetation cover. So until the regional council completes those actions that are required of it, the district council can't actually implement the relevant clauses of the NPSIB. And lastly, the interrelated nature of the NPSIB provisions. For example, many provisions refer to SNAs and are therefore contingent on SNAs being met. And just to expand on that final point, this arises because SNA is defined in the NPSIB as follows. And this is probably a refresher if anything, so I'll just give a few seconds for people to refresh their memories on that. So looking at that definition, SNAs are by definition areas that have been mapped in an operative or proposed district plan. Therefore, all NPSIB provisions which use SNA or significant natural area engage that particular meaning in terms of the definition. Provisions which refer to SNAs are premised on SNAs being mapped, to put it another way. If SNAs have not been mapped in the operative or proposed district plan, as is the case for the Far North, the relevant NPSIB provisions cannot be given effect to until the SNAs are mapped. Given the many references to SNAs in the NPSIB provisions, this issue makes it impracticable to implement much of the NPSIB. And again, if you go back to Mr. Wyeth's Appendix 3, you'll see exactly where he's identified this issue in relation to which provisions. The factors above all go to the question of whether it is reasonably practical to give effect to the NPSIB now. In my submission, they support Mr. Wyeth's conclusion that a future plan change will be required to fully give effect to the NPSIB. However, if there are no practical barriers to giving effect to the NPSIB provisions immediately, appropriate changes should be made through council decisions. Accordingly, Mr. Wyeth recommends the following interim approach and decisions on the PDP until the NPSIB can be implemented in full through a future plan change. And this general approach aligns with the issues that have been identified above. So not give effect to NPSIB provisions relating to SNAs due to the procedural and technical requirements having not been completed. Not give effect to NPSI provisions that require further engagement because that hasn't occurred and it needs to be done properly in accordance with the NPSIB. Require further technical assessments, not give effect to provisions that are primarily directed at regional councils or are subject to prerequisite procedural steps that must be completed by the regional council. So again, that very much aligns with what I've set out above. And this final paragraph is provisions that should be given effect to. So give effect to NPSIB provisions that are more general in nature and can be given effect to through specific policies in the IB chapter. And some examples of this that you'll see in the Section 42A report are the precautionary approach, priorities for restoration, resilience to climate change, and alignment with the general direction of the NPSIB. And Mr. Wyeth has recommended some changes to achieve those things. As stated above, whether it is reasonably practical to give effect to the NPSIB depends on the circumstances. Mr. Wyeth has identified a range of factors which make it impractical to give effect to many of the NPSIB provisions now. In summary, Mr. Wyeth has recommended changes to the PDP to give effect to the NPSIB where reasonably practical, but it is premature to try and give effect to many provisions in the NPSIB until the relevant procedural and technical requirements of the NPSIB have been satisfied. This is consistent with the legal position above. In conclusion, Mr. Wyeth's reasons and recommended approach properly satisfy the requirement to give effect to the NPSIB as soon as reasonably practicable. They are also in accordance with the other statutory considerations, including the Council's functions under Section 31, protection of significant Indigenous vegetation under Section 6, and the requirement to have regard to the intrinsic values of ecosystems under Section 7. And that concludes my submissions on that. We have gone over a bit, I'm sorry, but I'm happy to answer questions. I'll just stop sharing this.
Yeah, well, thank you very much for your legal submissions. They're sort of quite clear. Obviously, we're going to be in quite a space between now and when we release actual recommendation reports. You're correct. We aren't going to be releasing interim recommendation reports. We are going to deliberate informally. We have also the option to issue guidance. And we'll consider whether we may need to issue some guidance with regards to some of these matters as we move forward. So as I take it at the moment, I mean, when you say the NPSIB can't be implemented now, I'm just sort of wondering what the word "now" means, as in today or the day we issue recommendation reports.
Yeah. It is. I think you're right, Mr. Chair. It's going to be a bit of a moving feast. It can't be implemented now, and the issue needs to be reevaluated effectively at each step in the process. So, I would suggest that. I mean, the panel members will no doubt be keeping an eye on the news, but the council officers could keep the panel abreast of any developments with the amendment bill as it proceeds and keep you updated, because you'll effectively need to apply the law as you find it when you're doing your full deliberations and making your recommendations.
Yeah, so I mean, because at the moment a bill is just a bill. We're not directed by anything contained in a bill, but if it follows its statutory process, it would likely be due by the end of this year, and we've got hearings right throughout most of next year.
Yeah.
We're assuming that, well, if all things go as planned by the government, this will be law by the end of this year. But then, of course, and other changes to other instruments as well, including the whole RMA framework as well. So that space may change by the time we get to decision or recommendation reports as well, wouldn't it? Correct.
That's correct. Yeah. Yeah, and you're right. It is just a bill. It's been outlined here because it's so you're cognizant of it and you know that it's in the pipeline. You probably already did, but just to know that things might change by the time you come to make your recommendations, and you may well be applying the law under an Amendment Act.
Yeah, that's right. Yeah, so when I make a statement, it's just a bill, but it obviously sets a very clear direction. Anybody else got any other questions or comments? Thank you very much, Mr. Fisher.
Thank you. Thanks, everyone. Bye.
Okay, so where are we at with the council presentation now?
We're complete.
Nothing more to add? We actually said that our first submittal would come up at 10 to 11, which is pretty much close to what we are now. But I think we would like to take a morning tea break. Are you happy for us to do that?
Yes, thank you.
Yeah, I think so. What we'll do is we'll take 20 minutes. Right, we'll come back at quarter past 11, and you can take your position up here at the table. And thanks, council officers. There was probably a few more questions that we wanted to direct to you, but we've got the opportunity at the end of day 4 where we'll give council officers a chance to have a verbal response to the evidence that's been presented. You've obviously got the ability to have a written reply, but there may be a few things you might want to get off your chest or to give an indication of after it's clearing your head and give some direction to us of what you're thinking. So we'll be allowing you an hour or so to wrap that up. And I think before you do that, we can probably wrap up those other questions. We might just see where we get to at the end of today, and we might come back and ask a few more questions of you, but we're sort of conscious to try and follow the timetable now. So you're happy to be flexible like that?
Yeah, absolutely.
Okay, great. Okay, well, we're adjourned until quarter past. Thank you.
Stopping the recording, and I will be